With respect to the area of estate planning, the emphasis on asset protection has increased significantly over the last several years. One of the primary reasons for this is the federal estate tax exemption is now permanently set at $5 million. Along with an inflation increase, that amount is going to increase every year. Also, with the issue of portability, a spouse can now transfer that federal estate tax exemption to a surviving spouse, which provides over $10 million in estate tax exemption. Combined with the elimination altogether of the Ohio estate tax, the emphasis on estate tax planning has now shifted more to an emphasis on asset preservation or asset protection. Other reasons for this emphasis in asset protection is people are now living longer, and there's been medical technology has improved. For these reasons, people are concerned about their medical bills down the road. They're concerned about catastrophic illnesses. Also, the divorce rate is still quite high, and the United States remains the most litigious of all the wealthy countries in the world. So people are concerned about creditors in the future, and they're concerned about what they can leave for their beneficiaries down the road. So some of the recent events, at least here in Ohio, is one, the homestead interest exemption from creditors has recently been increased from a little over $21,000 to $125,000. Now, what does that mean? It means if you have a creditor out there, instead of being able to shelter a little over $21,000 in equity in your home, an individual can now shelter $125,000 worth of equity. Also, for a husband and wife, we're talking $250,000 worth of equity. Also, last year, there was a change that provided some clarity to the law when it comes to limited liability companies. So we now know that if you own an interest in a limited liability company, and if you have a creditor out there, their remedy is limited to something called a charging order. They cannot get to your ownership interest in that limited liability company. All they can do is, if that limited liability company does ever want to issue any dividends or distributions to you in the future, they can attach those. Probably the biggest change has been the enactment of the Ohio Legacy Trust Act. Now, an Ohio Legacy Trust is a self-settled trust, which means basically you set it up for yourself with your assets and you are the beneficiary. It's also sometimes known as a domestic asset protection trust. Now, what does all this mean? It means that I can set up a trust for myself in which I am the beneficiary with my assets, and I can protect it against my future creditors as well as the future creditors of my beneficiaries. I can receive the income from the trust. If there is real property or personal property in the trust, I can use those assets. I can change the beneficiaries on the trust. I can change the trustee. I can veto distributions from the trust. I can even get the principal from the trust as long as the trustee and the trustee's sole discretion wants to give that money to me. So, now a couple of things that a legacy trust cannot do is it cannot protect me from my current creditors. That's considered a fraudulent transfer. So if I have creditors out there now, or if I'm being sued, it can't help me, but it can protect these assets from anything that might happen down the road. Also, a legacy trust cannot shelter assets from Medicaid. But once again, if you've been fortunate enough to build up a nest egg, or if you're in an occupation where you might likely get sued, the fact that you can set up this type of trust to protect these assets down the road against any creditors that you might have or your beneficiaries, and that you can shelter these assets and ensure that they're passed on down to future generations, then the legacy trust is something that you would strongly want to at least look into and consider. Thank you. I'm Joe Balmer. If you have any further questions, please feel free to contact our office at 293-2141.